Good morning, and thanks for joining us for another edition of the Elville webinar series. Today is Friday, March 7th, and our topic for today is an area we focus on a lot here at the firm. Learn what elder law attorneys are advising clients in 2025, and your presenter is our very own managing principal and lead attorney, Stephen Elville. And I'm Jeff Stauffer. I'm the Community Relations Director here, and I'll be your moderator. Just a couple brief housekeeping items. We always encourage your general questions, so please note them in the questions panel, and we'll pause to address them. And if you have a very specific question, those are best suited to be talked about with Steve in a separate consultation. You also received the presentation slides that Steve will be talking about today by email yesterday. If you don't have them for some reason, they're in the section marked handouts on your screen to download. We also have some professionals here today. Welcome as well. And you may receive 1.5 continuing education hours for being here. So please send me your ID number or accreditation if I don't have it already, and I'll submit your hours and send out certificates today. Also, you receive a post-webinar feedback email right after the presentation, so please pay attention to this and take a couple minutes to share your thoughts about today's presentation. Also, a question for you. Have you achieved your planning goals, or have those goals shifted since you last looked at your planning? And here at the firm, we want to be a resource for your family and you. If that is starting from the beginning, if you have older documents that need to be reviewed, or an administration matter, helping a relative, whatever it may be, we can help you here at Elville & Associates. So I'm going to share just a bit about Steve and the firm. We're going to jump right in. A lot to cover and a busy day for all. So we are Elville & Associates, been around since 2010 and founded by Steve here in Columbia. We have many different practice areas that we work on here for clients, and they include estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, as well as tax planning and asset protection techniques for our clients. And we have 9 attorneys, 12 staff members in 3 locations, and we're coming to you live from the Columbia Gateway community location today. Our mission has always been the same, and it always will be. It is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at the firm. We do it in many different ways. Just a few of them include our planning processes with our clients, and we have different programs to suit all families and individuals here at the firm. We also host webinars and workshops in the communities that we serve many, many times each year. And also by way of our accredited client care program, we are one of only 2 firms in Maryland to have a CCP, as we call it here, accredited by the Client Care Academy in Boston. We have our first quarterly education event coming up on March 15th, and we're looking forward to that. And we also work with the ideals of client education, collaboration, and compassion in mind every day with every client here at the firm. And just a bit about Steve. Steve has been an attorney for many, many years, working in elder law, special needs planning, and estate planning. Member of many different national membership and professional organizations and peer groups, including the National Academy of Elder Law Attorneys. And he is a very seasoned speaker, presenting at many webinars, workshops, conferences, and continuing education events each year. And Steve was also named to the Maryland Super Lawyers list for a 10th time and a 9th consecutive year in 2025. So congratulations there, Steve. And also had a feature story written about him in the National Super Lawyers magazine about our charity, the Elville Center for the Creative Arts, which he founded in 2014. I'm very fortunate to be a part of. If you'd like to learn more about the Elville Center and how we work to make a musical difference in the lives of children each day, as we like to say, please reach out to me directly, and I'll be very pleased to share our story with you. Today, we have some elder law topics to talk about and educate about. So Steve, I'm going to make you the presenter.
Thank you, Jeff, and thank you for your very kind words this morning.
My pleasure.
And Jeff, I want to thank you also for this weather that you've brought. So thank you very much.
Welcome. My pleasure.
And I saw that golf picture behind you there. Are you planning on doing any golfing anytime soon, Jeff?
I'm going to be getting the sticks out, Steve, and finding where my swing is for the start of the year. It might be a little ugly, but I'm going to work on it.
Getting out to the driving range. Very good.
Yes.
Well, good morning, everyone, and it's really my privilege to be with you this morning and to really have the privilege to talk to you on a Friday morning. So thank you for spending your valuable Friday morning with us. We've started very efficiently. We're going to continue on in that vein very efficiently, and we're going to end on time. And we're going to be about an hour on this webinar. And gosh, I don't even know where to begin. We're talking about elder law in 2025, and no matter where you are on the political spectrum, we know that there's a lot of changes going on in the country. Those changes are going to be affecting the Medicaid laws and the delivery of Medicaid services. Some of you or many of you know others that have children with disabilities. Their benefits are being affected. Advisors on this webinar, your clients with people in their lives that have disabilities are possibly going to be affected by the changes in the laws and the reshuffling of the deck that we are seeing here in 2025. So I'm going to play it straight down the middle this morning and try to give you something that you can take away, something that you can rely on substantively to guide you as you think about elder law. And what is elder law? Well, elder law, in my opinion, is a hybrid of estate planning. So I was very fortunate back in the early phases of 2001 to really start to work for an estate planning firm here in Columbia, Maryland, that had a need for someone to work with older clients. And I learned the fundamentals of estate planning from a mentor who was also a CPA. And I also was able to work with older clients, people that are having issues as they age, issues with housing, issues with Medicaid planning, finding ways to pay for long-term care, dealing with incapacity issues, Social Security, veterans benefits, all of those things were kind of thrown into my lap way back when. So I was very fortunate to kind of evolve into what I would call a hybrid elder law or estate planning attorney, where we are very fortunate here at Elville and Associates to be able to deal with all of those particular areas in that whole genre, let's say. So we have clients that are wealthy, we have clients that are moderately wealthy, we have clients that are not wealthy at all, but their assets are just as important to them as far as the preservation of those assets. But back to elder law, and what is elder law, which really evolved in the early 1990s into a field of law. It is really, in my opinion, estate planning with an emphasis on disability planning. Estate planning with an emphasis on asset preservation for long-term care. All of those things are kind of wrapped up in that. And if I could do one thing today, if I could give you one thing that you could help yourself or help someone you know who is struggling with an issue in the world of elder law or aging, or someone getting older, a couple where one of the spouses has dementia, whatever that situation is as it relates to public benefits, planning, asset preservation, dealing with aging, dealing with long-term care, it is that you can help someone dispel myths. You can help them dispel fears and myths that really are devastating. I'm going to lose my house. I'm going to lose all my assets. How are we going to pay for this care? And we know, unfortunately, as we delve into 2025 here and all the other changes that are happening, we know that Maryland is one of the worst states. It's one of the worser states, I should say, to age in. And that's not going to be a surprise to most of you. And the reason why that's not a surprise is because Maryland, its legislature has not seen fit to help people stay in their homes. It has not seen fit to help people age in place without having to pay privately for Medicaid delivery of services in a nursing home. So in other words, if you live in Maryland and you're going to age in place in Maryland, you must be able to finance it personally, the way the things are now and the way that things have been historically in Maryland. You must be able to finance that personally, privately. You cannot rely on the state of Maryland to pay for Medicaid services to keep you at home or to pay for your Medicaid services in an assisted living or your long-term care services. That's just not going to happen in Maryland, except on a very, very limited basis. So we must take the point of view that Maryland is a difficult place to be, not for long-term care skilled nursing, but if we want to age in place in Maryland and do it with independence, do it with self-determination, we have to be able to finance that. And we have to understand the difference between the public benefit system and how it's delivered, and also how to think in terms of paying privately, which I'm going to encourage you to be thinking about that. So Despite all of the things going on the federal level, what we have in Maryland are a series of challenges. And I'm going to just keep going now on the slides. And we are going to advance. And as I now really get into the presentation after having set that stage, I just want to say that all this information is meant to educate. This is not an attorney-client relationship that we have on this webinar, so none of this can be considered legal advice, but we are going to try to deliver very high-level, macro-level information that you can take away. And as we look at this list of trends and so forth, some of these I've already kind of alluded to. And what you can take away from this workshop today is hopefully the information that if someone seeks the real information, if someone you love or know can seek an elder law consultation with someone who is competent in the world of elder law, they will save themselves so much time, so much effort, so much heartache, so much suffering because of misinformation that you will feel gratified yourself for having helped that person. So back to what I was just saying, not only do we have challenges at the federal level, but in Maryland. I listened to Dr. Adiban Basu the other day, which many of you listened to or have heard at the Baltimore Estate Planning Council meeting. He was outlining the state of the nation, the state of the world economically, and that of Maryland. And we have a deficit situation in Maryland. We have a sluggish growth or no growth in the economy. So this is not helpful to what we are trying to be concerned about in elder law, with Maryland already being a state that doesn't really fund aging in place for its citizens, whereas Delaware and some other states actually do much better in that area. So with that said, we have both eyes open. I'm sorry that sounds like a little bit of a negative introduction, but this is what we're dealing with in 2025. And I think that those of you in attendance today would expect no less for me to bring out that kind of foundational introduction about what we're going to talk about today. So we just talked about a few of the trends in Maryland, but I will now give you something positive. One of the big trends that we have is a new law over the last year and a half called decanting. And in Maryland, decanting is a very nice law that allows us to change estate plans where someone with disabilities is receiving a share that they shouldn't have received in an estate. So Maryland decanting is one of the good things. On the estate planning side, Maryland law has improved dramatically over the years since 2013, 2014. So I just want to plug in some positive things there for Maryland. But on the aging in place side of things, we are still struggling very much. So waiver slots, the waiver programs, the community options waiver, a lot of the other waiver programs, we are still challenged in Maryland. That is really what we are talking about when I say that Maryland does not do well in funding waiver slots. So if we think in terms of community-based Medicaid and long-term care Medicaid, like in a nursing home, the waiver slots are what we would call optional for the states. So the states can fund their waiver slots, but the federal government does not mandate that states have to fully fund those waiver slots. And that's why Maryland continues to struggle when it comes to long-term care for its waiver slots. Maryland has made great strides. For example, bullet point number 3 here, the augmented estate. So if you are a spouse, you have a spouse, God forbid, who is struggling with a progressive illness, that spouse can be protected through certain planning. And Maryland has put its stamp of approval on that kind of asset protection. So there are some really positive things with decanting, the augmented estate, and Maryland's approach to some of those more benefit-based programs, but not for aging in place. Elder abuse continues to be on the rise. What can we say except we have to protect our elder citizens? Cost of care continues to rise, no surprise. It's shocking how much memory care costs in a quality facility. It's shocking how much long-term care costs. On another positive note, older adults can engage in supported decision-making as a way to further their rights of self-determination. So we're talking about so many things here, it's mind-boggling, not to mention the environment we're living in. But we are going to take away some specific things today as we just started here in the early going, giving you an overview of what is really happening. So when someone comes to see elder care attorneys or estate planning firms that have elder law focus like ours, they're coming for the same reasons as they came last year and the year before. And that is that people are not educated. They are not educated about the whole ambiguous world shrouded by mystery in elder law. So when they come to see an attorney, we are going to turn on a light switch in a very dark room, and we're going to illuminate information that will give that person the ability to make decisions, the ability to move forward. And that's one of the things that after all these years, I feel very good about, that I've been blessed with the ability or the opportunity to be able to do that. And no matter what elder law attorney you may see, that is what you should expect, that the situation can be analyzed, whatever that situation is, and a path forward can be carved out. So people come to see elder care attorneys for issues related to aging, obviously. There's a push because of a crisis. Or it's a pre-crisis situation. There is no crisis, but they want that person or that couple wants to start an asset protection process to get a pre-crisis plan into place to preserve assets for long-term care. There could have been a sudden change of circumstances, such as a diagnosis of a progressive illness or a crisis, such as a stroke, God forbid. Parents could be aging, grandparents, disabled children, disabled spouses, and of course, other elder care related issues such as housing, Social Security, all of these kinds of issues. Now, healthcare decision making in Maryland. Get yourself educated. Go to the Attorney General's website. This is what we're talking to people about: flexibility and also understanding MOLST, M-O-L-S-T, the medical order for life-sustaining treatment. Financial decision making. If we were to really be honest as attorneys, we would say the most important thing in elder care, the most important thing in estate planning in the world is financial decision making. The financial power of attorney is the most important of all the documents, even though, of course, all the documents are important. The financial power of attorney in the eyes of an attorney is the most important of all documents. Why? Because you can build in flexibility at a time of crisis. And also why is because people are living a very long time. So if you're on this webinar and it all gets confusing, remember, your financial power of attorney and your healthcare directive, they govern what happens in your lifetime, not at your death, when and if you become incapacitated or marginally incapacitated. In-home care management. Many people are improvising, many people hire home health care agencies. We are advising people about this, including aging life care management. Aging life care management. Perhaps other than the elder law consultation advice I gave you, one of the most important things you can take away is to utilize great aging life care managers. Here in Howard County, we have Allison Stanton, we have Marcy Koenig, we have Jill Rossner, and others. In Anne Arundel County, Baltimore County, and Montgomery County, all the counties, Carroll County, there are advisors like aging life care managers that are available. They are essential to you having the tools that you need, and for elder law attorneys to have the tools they need to do what we do. Nursing home and assisted living placement. We are reading contracts. We are interpreting them. We are advising people about these contracts. Estate planning. So if you don't have your will or your revocable trust or irrevocable trust or financial powers of attorney and advance directives, if you don't have those in place, you need to get those in place as you age. If you don't have those in place, bad things can happen. We're going to talk about that in this presentation. Asset protection, various types of asset protection. Today, we're going to be focusing on elder care asset protection. Limiting liability. If you have people coming in your home, how can you limit liability? If you have someone disabled living in your home, how can you limit liability? Medicaid, Medicare, all of these things we are covering in the world of elder law. I failed to mention continuing care retirement communities, huge issues for people to understand what they are committing to when they go into a CCRC. So what is an elder law consultation? Well, it was one of the first things I was ever mentored or told to learn or learned from mentors as I became a young elder law attorney many years ago. This is basically a 1.5 to 2.5 hour consultation. It is a basis for information, turning on that light switch so there's no more darkness and the person can see and they can open the curtain to see what the ambiguous world of elder law is all about, identifying problems, fact-finding, dealing with incapacity issues, dealing with the costs of long-term care, advising about these things, including life care managers, asset protection techniques, and really giving people a lay of the land about what they are doing and where they are going. It serves as a basis for planning, as I just mentioned. It could serve as a basis for a planning shift. A particular couple or person may have done conventional estate planning, but now they're shifting to what I would call elder care planning. The plan has shifted, life has shifted, circumstances have shifted. One of the things I mentioned earlier, this kind of counseling resolves ambiguities, misconceptions that really are devastating. I'm going to lose everything. No, that's not going to happen. Most of the time, that is not going to happen. I don't know how I'm going to deal with this cost of care. Most of the time, nearly all the time, that can be addressed, okay? A sense of direction, a sense of empowerment, going from a sense of weakness and powerlessness to a sense of power, and addressing weaknesses in the family or bolstering family unity if that exists. And if we are dealing with a situation where a family has unity, all of us know on this webinar that that is a good thing. Jeff, you can interrupt me at any time, as you know, but I'm going to keep going in the interest of time, and I'm going to assume that there are no questions. We're going to launch now into a discussion of asset protection. Now, asset protection is a very broad subject. There are asset protection states like Delaware, Nevada, Alaska, Wyoming. What does this have to do with elder care? Well, there are various definitions of asset protection. There's lifetime protection. There's long-term care asset protection, which is what we're going to focus on today. And there is asset protection at death. Let's jump into this subject. Many of you on this webinar this morning may know some of this, but during our lifetimes, asset protection, protection from creditors, protection from bankruptcy, protection from divorce, protection from the results of a car accident where someone could sue. This is hard to attain during life. However, if you're married, you do have a basic level of asset protection in assets that are owned as spouses, tenants by the entirety. So this is a very fundamental level of asset protection. We want to check, if you're married, how much do you own as tenants by the entireties, and how much could you own if you could bolster up your very basic asset protection. Life insurance is protected from the claims of creditors, so long as a spouse or child is the beneficiary. For those of you who are not married, I apologize, but we're talking a lot here about married people or for someone who has a child. Annuities are protected from the claims of creditors if your spouse or child is the beneficiary. Qualified plans, 401ks, 403bs, thrift savings plans through the US government, which is a 401k, and IRAs enjoy asset protection. Protection for inherited IRAs does not exist, however, when we pass away and leave those assets to others, children, grandchildren, nieces and nephews, others. They do not have asset protection in IRAs unless you specifically provide for that. So that's kind of a foundational idea that during lifetime, we have asset protection in certain things, but it's more difficult to obtain asset protection during life. But you'll see here at the bottom, domestic asset protection trusts. I should just say irrevocable trusts that can be created during life. Life insurance trusts, spousal trusts, marital trusts. These kinds of trusts that are created during life do have asset protection, but we have to work hard for some things during our lifetime to have asset protection, whereas other things like life insurance, annuities, tenants by the entirety property, and qualified plans do enjoy asset protection in and of themselves. Now, in the world of long-term care, which is really what we're talking about this morning, elder law, one of the most powerful tools is something called a Medicaid asset protection trust. This is arguably not even just limited to elder care world. This is one of the most powerful tools that has been created in the last 20 years in estate planning. So through an asset protection trust, you can do pre-crisis planning. You can start the look period, the 5-year period that many of you have heard of. You can also use a similar trust called a veterans trust. This is a hybrid trust created for people who want to qualify for veterans benefits, but use the trust as a powerful tool. These trusts allow a grantor of a trust to be able to divest themselves of assets and still enjoy certain tax advantages, limited control over the assets, and asset protection from the claims of the beneficiary's creditors. So these are very complex subjects that need to be outlined on a whiteboard, and we will not be able to do justice to them today in this workshop. But I want you to get a feel that these are powerful tools that are available for the person who could properly utilize them. Trusts under wills. This is a strategy since 1993 that the federal government has allowed, and it's come down to the states, and it's come down to our Code of Maryland regulations. This is a strategy to preserve assets should a healthy spouse die first, where we have a spouse who's not well, a spouse who has dementia, a spouse has progressive illness. This is a strategy that helps preserve assets if the unexpected happens. This is what I'm hoping you're gathering as you listen to this discussion on asset protection, is that asset protection is about building layers of protection. And it's also about specific strategies in elder law. Crisis planning, we talked about the 5-year rule, the look back period. I would encourage you to think of the look period as a look forward period. And having flexibility in estate planning. Robust powers of attorney that provide flexibility is the foundation of elder law. And it allows, at a time of crisis or at a time of near crisis, it allows your agent to do those things that you would have wanted them to do to bring flexibility to a planning situation, which really translates to the preservation of assets. The rule of Hamps, for example, even if you did no other planning, but you were a single person who had a certain amount of assets and you had a crisis and you had to go to a nursing home situation, not an assisted living, but a skilled nursing home, through the proper power of attorney with the proper flexibility, you could, or your agent could for you, preserve 50% roughly of your assets, no matter what happens, and still get Medicaid benefits. Hard to believe some of these strategies exist, but that's why we're talking about them today. A life estate deed. A life estate deed is a simple way of being able to start the five-year period, so long as the person who is granting the deed is willing to give up their control over the power to sell. This is sometimes a viable strategy. Sometimes it's not as good as it seems because it provides for no flexibility. But it is a strategy, and sometimes we do use that strategy. Last but not least in asset protection, we have asset protection planning at death. So we just talked about elder-centric strategies for elder care and long-term care. These are strategies that have been used for years and years, and it's possibly the easiest thing to structure, which is what happens if I die and I leave a trust for beneficiaries? Well, if that trust is structured properly, that trust will provide for asset protection, depending on the trust structure, who's the trustee, how the powers of appointment, which is beyond today's discussion, how are those things structured, But just be assured that at our death, if you want to protect a spouse, a child, a grandchild, a loved one, you can achieve your goals, including protecting people with special needs, of course. And Elville and Associates is extremely blessed to be a go-to firm for special needs planning and for people with disabilities. So we are very blessed and take that responsibility very seriously. So asset protection has various aspects, and hopefully I've given you a little bit of an overview this morning, and I'll go back one slide just to say, with a focus today on asset protection or asset preservation in the long-term care context. Jeff, I'm going to stop for just a second. I'm not looking at the attendees right now. I'm looking at my screen. Do we have any questions, Jeff, or would you like to pose any kind of a question to the audience?
No questions as of right now, Steve.
Thank you very much, Jeff. We have a very studious crowd, and we welcome your questions. I know that given what's happening here since the election, I'm being pretty intense in the conversation just to try to drive home some of the information today. And I'm trusting that the audience is making notes, using their tablets, using their phones, Androids, iPhones, whatever it may be, to take down notes and to be able to take away something to help themselves or others. All right, so now.
Steve, looks like we do have a question here.
Oh my goodness, okay, Jeff, great.
Okay, before we jump into another topic. So related to Medicaid qualifying, does Maryland still participate in long-term care partnership program? Can a person potentially protect legacy assets, for example, $250,000 if they have a long-term care policy that provides that amount of care coverage of $250,000 or more?
That's a wonderful question. To my knowledge, the answer is yes. Now, if you will email us, I will specifically double check that. But to my knowledge, I have not heard anything to the contrary. And I think that is a wonderful, wonderful thing if you have that long-term care policy and you're excluding, for those of you who are not aware of what the question was, there is a way to exclude a certain amount of assets under a partnership agreement if your long-term care policy is a partnership policy where your willingness to purchase long-term care insurance would also give you a reward that that amount of assets would be excluded should you ever have to spend down for Medicaid. So thank you for that question, and I have not heard anything to the contrary that is not still the case.
Great, thank you.
All right, so well, now someone comes to an elder law consultation. You hear me today telling you how important this is and how it almost always clears a path forward and gives a person peace of mind. How can I pay for the cost of assisted living or long-term care? Obviously, this is the big issue. Will I lose my home? Most of the time, the answer is no. It's a misconception. It's a mystery. It's a how should I say it? A misconception, a myth. How will I survive in the community? Well, the federal government has provided baseline rules for this. It's not great, but it is at least a pretty robust way of trying to get to protecting the community spouse if your spouse has to go into a nursing home. How do I preserve our assets? There are various strategies to do that. Where is the best placement for my loved one, and how do I deal with that? Should I use a placement specialist? Should I use an aging life care manager? Healthcare decision-making issues. I have agents. How do I educate them about making decisions? Or no, I don't have agents, and how am I going to deal with this because I don't have anybody to make my decisions? There are ways of getting to that issue. Will I need a guardianship? Well, certainly we want to avoid guardianship, but sometimes with disabled loved ones, there is no other choice other than trying to avoid guardianship with supported decision-making. Sometimes guardianship is needed. Can I get veterans benefits? Well, since 2018, the VA rules have been modernized. It is still challenging, and most of us heard just the other day that the government is talking about cutting 70,000 jobs at the VA. We just don't know what kind of world we're going to be in, but veterans benefits and the analysis of veterans benefits, if you or your loved one served in a major period of war, we want to see the DD-214, the DD-214, which is the service record to see if the veteran can qualify for a tax-free benefit called aid and attendance. Asset titling questions. How do I title my assets so that they actually flow with my estate plan or flow with my elder-centric plan? How do I deal with the cost of care or with the care plan for my loved one? Who are going to be the advocates for my loved one? Should we move to a CCRC? And if we do, can we still preserve our assets? Well, the answer is you can't really preserve your assets in a Medicaid asset protection strategy if you move to a CCRC, but the CCRC will be grateful if you are a veteran that qualifies for benefits and you cannot perform some of the activities of daily living and you get the tax-free benefit. They will love that because that will help you pay for the cost of care at the CCRC. Now, at the elder law consultation, there could be changes to the estate plan, updates to the estate plan, shifts in the estate plan, transfers of assets, as you see here in these bullet points, shifts in how healthcare decision is made, huge issues that are sometimes very difficult about placement. And again, aging life care managers, I'm being redundant, very intentionally here to drive that home. Cannot strongly emphasize that enough, the value of a good aging life care manager. Now, if a couple comes to see an elder law attorney, I'm just going to speak for myself because over the years, having done hundreds or thousands of these consultations, I have formulated this kind of result in my own mind in a way to try to bring this information to someone and boil it down to what happens next. So some people are going to be satisfied to build flexibility in the planning. The circumstances are not a crisis. Build the flexibility, build that foundation, address the costs of care, the costs of long-term care, the cost of long-term care insurance or a hybrid product, or for those of you on the call who are professionals and sell these products or advise about these products, a long-term care policy that's built into a life insurance policy, and full educational counseling. This is really the basis of someone who is not experiencing a crisis, and I would call this the wait and see approach. Building flexibility, having a foundational estate plan with maximum flexibility in the powers of attorney, that person is now ready for the future. Sometimes we're dealing with a married couple here in this example, we are dealing with building this flexibility, but there are going to be asset transfers. We are going to get assets out of the name of the person dealing with the crisis or the pre-crisis, the dementia, the progressive illness. So sometimes we're building foundation and we're then divesting assets out of that person's name, okay? Or in the third tier, we are doing what we call full-blown pre-crisis planning. The person or the couple is divesting themselves out of assets, either outright, which is not advisable, or in a Medicaid trust in a controlled way, where they are starting the 5-year Medicaid period. Or there could be a crisis that's occurring, and now we're trying to preserve assets for the well spouse. In that circumstance, we want that couple to have a financial power of attorney in place so they do not have to petition a court at a time of crisis when everything else is upside down. Now they have to go to court and ask for this permission from a court. That is a very expensive and tough thing to have to do. It's much better to have the flexibility built so if there is a crisis and there's a well spouse living at home, the assets can be mainly preserved for the well spouse, no matter what the terrible situation that may be occurring on the side of the ill spouse that's in the nursing home. For unmarried persons, we want to do the same thing, except just a little bit of a difference. We want to build that flexibility, address the cost of care, address the full counseling, but it could just be a wait and see situation. We see many routine, many conventional estate planning clients that want to get this kind of counseling so they know what they're dealing with in the future. For the single person, it could be exactly the same with a pre-crisis plan of divestment, outright or in trust, and As I mentioned earlier, for a person who is single, they are not married, we do not have, at the time of a crisis, we do not have the same flexibility as we do for a couple. So a person who is single at a time of crisis, we would want to have those flexible financial powers of attorney in place in a perfect world, so that the person with disability here that's suffering in that crisis, that person's assets can be preserved at least 50%, roughly 50% of the assets. Now, I mentioned incapacity planning. I continue to mention flexibility. Let's get to the heart of that. The heart of it is very simple. Estate planning is about flexibility, and to my mind, in 2025. But so is certainly elder care planning. So understanding this is the key, one of the keys for today. If you or your client do not have advanced directives and powers of attorney, and if on the financial power of attorney side, if those documents are not understood, so I'm going to stop right here. Many people on this webinar are going to be, and it's fine, it's not wrong, it's not horrible, but many of you think that financial powers of attorney are all the same. Many of you think that they are plain vanilla. All the powers of attorney documents out there are all the same, and nothing could be further from the truth. Powers of attorney come in different varieties. They come in different flavors. Some of them are weak. Some of them are too general. Some of them don't address long-term care issues. You want to make sure in a perfect world, depending on your family situation, your situation with who you have available to you to be your agent under a financial power of attorney, you want to build as much flexibility as you can. And I'm talking about a flexibility to be able to do divestment planning, gifting, compensating your agent for their service, incentivizing them to keep you at home, powers to create trust, whatever it may be that you feel comfortable, and maybe you don't. But if you feel comfortable and you are fortunate enough to have a situation where you can trust those people that will be your agents, you can build flexibility into your planning. And that is the most important thing I could convey to you today, other than the elder law consultation to relieve suffering and give people information. This is the heart of elder law, the avoidance of guardianship and flexibility in the financial powers of attorney. You could be a person who does not have that situation, and you're not comfortable giving this massive flexibility. But if you are doing yourself a favor for future planning and for asset preservation. There is a Maryland power of attorney, and there are various forms of the Maryland power of attorney. It has evolved over the years. I'm not going to spend too much time on this, except for that you will see in these slides as you look at them privately that the Maryland power of attorney is probably not enough for doing this kind of planning. So even though Maryland has cleaned up its power of attorney laws, has made a very, very valiant effort to provide the public with power of attorney documents that are enforceable and predictable, and the agent has responsibilities, and we are not in the horrible situation we were back in 2008 and 2009. But this financial power of attorney, which is statutory and pretty static, it is probably not customizable enough to do the kinds of things we need to do in elder law. So just bear that in mind, that a customized general power of attorney, in addition to your Maryland statutory power of attorney, would be the approach that would probably solve most of the problems we might face in a long-term future. Why do I talk about this in such a long-term context? Because people are living many, many years. And many of us have been practicing law long enough to see many clients live over age 100. And we know that it's possible in this world today to live on this earth for many, many years. I'm switching now to the advanced directives in the interest of time. We want you to see these, feel these, work with these, struggle with these, mark them up, customize them, make them personal to you. Why? Because this is the only thing your loved ones are going to know you wanted, other than what you said to them verbally during your life. So some people are going to say, Steve, I don't believe the financial power of attorney is important. I think the advanced directive is my most important document. And that's a perfectly valid opinion. So use these documents, customize them. They are not strictly formal. These are informal documents that you can be creative with. Do you have to be? No, but we encourage you to customize and be creative. The medical order for life-sustaining treatment, you need to educate yourself about this, educate your agents about this, talk to your doctor about this. Maryland remains one of the only states that requires the medical order for life-sustaining treatment. Educate yourself, go to the Attorney General's website, or we can refer you to an aging life care manager to educate you on this. Now, I promised to be efficient, and it looks like we were so efficient that we are done about 14 minutes ahead of time. And we're going to have plenty of time for questions, but also we're going to be done for sure by 11 o'clock, and you can resume your daily activities. But we've gone through a whirlwind of what's happening in 2025, some of the things you are hearing in the news, some of the things you're being personally affected by, some of the things that your imagination may be running wild about. But we're also talking about what's going on in Maryland, what's going on in surrounding states, the importance of incapacity planning, the elder care type information, the elder-centric information that's available to people, that if you reach out, you can get this information. You can have someone you love who's very worried about this stuff. You can have them educated, give them more peace of mind and a path forward. It's difficult. Elder care is ambiguous. It is not as, it's about as clear as mud to some people. And even when we are dealing with it on a daily basis, we are dealing with the juxtaposition of tax law and Medicaid law and veterans benefit law and federal law and state law, Code of Maryland regulations, all of it's coming together. And then we are dealing with a situation in Maryland where we do not have a robust aging in place type of program here in Maryland. So you have to understand levels of care. You have to understand the resources that are available to you. And of course, working through your financial advisors who we collaborate with as partners and your CPAs to try to craft a path forward privately for the financing of your own long-term care. But knowing that these other systems are in the background, it all hopefully would come together if you ever need to learn more about this information. So we encourage you to set a consultation with us. Email Jeff, email me, email my assistant, Barbara. Call Elville and Associates. There is no reason to be fearful about this. If you consult with us, there is nothing to fear. It's all attorney-client privilege. So when an attorney meets with you, even if you do not retain the attorney, the meeting is attorney-client privilege confidential. We want you to complete an estate planning or elder law questionnaire, put you to work a little bit to get us the information we need to be able to help you. We want to see your current documents if you have any. And if you don't have estate planning documents, do not be embarrassed. Most people do not. We will help you get those documents in place. If you do not have a collaborative advisory team, what do I mean by that? If you don't have a financial advisor, if you don't have a CPA, if you don't have a life insurance specialist, if you don't have an aging life care manager contact person, or any other professional, we want to help you put that in place. And then we enjoy answering questions. I know we only got really 1 or 2 questions today, which is fine because I was talking a lot, but we do enjoy questions. Please bring your questions and your concerns to our table here. We have 4 conference rooms at Elville and Associates. We can also do virtual meetings to try to bring this information to you. We want to give you time to think, but we also want to, in the world of elder law, relieve suffering and relieve anxiety where there is so much ambiguous information and myths that are thrown out that it can really throw people off. But we want to provide a path forward for you or a loved one or a client of yours. So Jeff, I'm going to turn it back to you. And I want to thank everyone for their time and attention through this pretty intense 50 minutes that we've just gone through. And I think we have time for questions, or we will simply end early and let everybody get to their weekend which is coming up. So God bless everyone. Jeff, I'm going to turn it back to you.
Well, thanks, Steve. Really powerful and efficient but intentional presentation, I would say. Lots of really important info. We do have a question here. Now's a great time for your final questions. Steve, I have one quick question for you. What percentage, you talk to so many people on a daily basis, what percentage of people would you say that you talk to, how many of those people would have benefited by working the plan earlier as opposed to finding themselves in a crisis and having to try to expedite things?
Oh, Jeff, I would say, first of all, I guess the way to answer that would be, 55 to 62%, something like that, of people in the United States have no estate planning at all. And that means about 45%, 40 to 45% of people do have planning. The challenge for the people that do have planning is they don't update like they should. So laws change, situations change, life changes, health changes, people's address change, family situations change, but yet that couple or that person does not update their documents. So that's the first problem there. And we want to nip that in the bud through routine updating. But to get to your question, people that have no planning at all, that's a problem, because see, when someone has a crisis, and that's what we're really talking about in elder law. Now, on that side of the thing that we're talking about here, planning, when someone has a crisis, there is no baseline for management. So the person could lose their right of self-determination and be under guardianship. They've lost flexibility as far as preserving assets for their loved ones. So trying to answer that very good question, I would say 100% of the people who don't have planning should have planned earlier, because if for no other reason, they have not planned or built in any flexibility. On the other side of the fence, where people do have some planning, I'm going to say probably 50 to 60% of those people should have updated and didn't, and may or may not have had the flexibility that they could have had, or their planning did not change over time to address some of the issues that should have been addressed. But the good news is, for the 45% that did planning, most of those people who did planning with a firm like ours would have addressed the issues of flexibility in advance. So it's a very, very good question. I hope I've somehow attempted to answer it properly, but I would just say updating for those who do have planning, getting something in place for those who don't, that is the key.
Thank you. Further context from a great advisor like Steve, so thank you. So let's go through a couple of questions and then we'll wrap up. First question is, can the financial power of attorney be combined with the general durable power of attorney in one document?
Thank you very much. I would say, Jeff, can you repeat that question, the first part of it?
Can the financial power of attorney be combined with the general durable power of attorney in one document?
Good question. So in my opinion, and this is not necessarily the opinion of every other lawyer, I would say if you meant the statutory power of attorney, the state form, can they be combined? My answer is no, because a very simple-minded view of the statute, which is the Maryland Power of Attorney Act, says that the Maryland Power of Attorney has to be in the substantial same form as the code says it is. So in other words, we don't want to change that, in my opinion, because in the world of elder law, we're dealing with ambiguity. So at some future crisis situation, would we want a situation where the Maryland Power of Attorney is not enforceable because it does not look substantially similar to what it is supposed to look like? And I know that's a very simple-minded way of looking at it, but my idea would be, don't mix the two of those together if that's what you meant. Keep them separate, have a separate general durable power of attorney, and that hopefully would answer the question as to why I would feel that way.
Okay, and last one for now here. Can you talk just a bit further about the aid and attendance related to veterans during wartime?
Yeah, so I want to just mention this. So for certain qualified veterans, people that were actually in a period of war, for example, World War II, Korea, Vietnam, or the Gulf era, okay, they do not have to have been in combat. Now, that is a myth. But if they qualify, as a veteran who baseline meets those eligibility requirements, then in the future, and there are asset limits and so forth, and there are issues related to how much is the cost of care versus how much income the person has. And there are various techniques to get the person eligible for veterans benefits. And the VA has many pensions. And many of the pensions have very funny names. This particular pension for people who are aging is called the aid and attendance benefit. So it is a tax-free income for the veteran or for the veteran's surviving spouse if he or she is not remarried or divorced, I should say. So this is a tax-free income that can really have a lot of power over time. The biggest problem we see with people with the aid and attendance benefit is some people were not aware they were eligible, and they could have been getting this benefit for 10 years, which is really quite cumulative over 10 years. So I would just encourage you, if you have someone in your life who is a veteran, they served in a period of war, or even if you're not sure, to get us the DD 214, and then we can determine whether that person is going to be potentially eligible for aid and attendance when they are no longer able to do certain activities of daily living. And then there are people who have service-related disabilities, and for those particular types of people, in those cases, it doesn't really matter what assets they have. But for people who have problems with the activities of daily living and aging, who are otherwise financially eligible, they can get this tax-free benefit. So it can be quite powerful over time. It does not apply to a nursing home situation. It does not apply to skilled nursing, but it does apply in a very serious way to living at home and receiving the tax-free income, or living in assisted living and receiving the tax-free income for that veteran.
Steve, thank you so much. So looks like those are our questions. Thank you all for being here. As always, I'm going to send out our recording for today. We have a YouTube channel that is home to hundreds of in-person and webinar presentations, and you can go back and see how much Steve and I have aged over the years, and get a lot of great information from that. I'll send that link to you as well. Also the slides and some other resources. And our webinar series goes forward. I'll send out the list of what we have going on, just a couple of highlights to finish. If you're looking for an evening presentation, next Wednesday at 7 o'clock, we'll be doing estate planning and elder law essentials with Steve. And then on the 20th of March, Documents for Life and the Family Love Letter, a new presentation by Lily Hummel, who's our principal attorney in the Rockville office, and she'll also be with a chartered special needs financial consultant, Courtney Haycoop from Cloverleaf Wealth Strategies. So that should be really interesting. And then just to round it out, webinar presentation, Housing Options as You Age, with Victoria Hathaway, who is associated with the Commission on Aging in Howard County, director of the Bob Lucido Team Silver Group, and also the Office on Aging and Independence for Howard County. Emily Leclerc will be there, and that should be a really powerful one. We almost have 100 people registered for that already. So lots of great information coming up on the webinar series, and if we can help you here gather information and understand how we can help you with your planning, contact us here, and we'll be happy to be a resource to you. So Steve, thanks very much. Talk to you soon, and talk to you all soon again on the Elville webinar series. Have a great day.